In a ruling that not only blocks the feds from forcing commercial fishermen to pay for essentially the quartering of government troops on their boats, but also lets observers study the lexicographic legerdemain of politicians and judges who use words such as regulation and rule rather than threat of government attack and edict. Well, in a big ruling, the U.S. Supreme Court on Friday, they actually ruled in tandem on two cases that have the same root question. And that question is whether regulatory agencies can expand their so-called power if the agency creating statutes written by Congress happen to be ambiguous. And this move by the Supreme Court is going to slow down a lot of regulatory expansion. The question is whether the ruling goes far enough. Hi everyone, I'm Gardner Goldsmith for MRC-TV, and the cases are called Relentless Incorporated versus Department of Commerce and Loper Bright Enterprises versus Raimondo. They pertain not only to the federal government forcing fishermen in Rhode Island and New Jersey to bring so-called fish counters or fish monitors onto their boats, but also to the agency expansion of that demand, an expansion that forced the fishermen to pay the salaries of these sardine Stasi on their boats.
One fish, two fish, red fish, blue fish, black fish, blue fish, old fish, new fish.
And as one might have guessed, the two-in-one strike down of the expansion, well, it doesn't address the root problem of Congress creating the agencies in the first place. The dispute goes back to at least 2016, when atop the extant statutory demand that the fishermen welcome the agents aboard, the National Marine Fisheries Service, NMFS, claimed the power to force fishermen operating within so-called U.S. waters, 12 miles or less from the ocean shore, to pay the interlopers as well.
6 fish.
The petitioner's brief for the Loper Bright side of this, brought by a New Jersey family, a fishing company that was being driven out of business by the expense of the fishing monitors, well, it explains the dispute and the financial impact of having to pay each monitor upwards of $700 to $800 a day. Quote, seizing on the statute's silence and purported ambiguity, NMFS declared that domestic vessels in the Atlantic herring fishery would have to cede upwards of 20% of their returns to pay observer salaries, end quote. Of course, the amount isn't really relevant. It's the principle that counts. But what really is the principle here? Well, that's something that the Supreme Court might appear to have explored, but they really didn't. Indeed, with these rulings about the expansion of the fish monitor requirement, the majority ruled on whether the process of government lording over fishermen was conducted in a so-called proper way, not whether the lording over itself is proper at all. The petitioners targeted a 40-year judicial standard established in the 1984 Supreme Court case called Chevron v. Natural Resources Defense Council. It was a ruling which itself had seen the Chevron oil company challenge the 1981 expansion of a 1977 Clean Air Act amendment pertaining to emissions from numerous kinds of power plants and oil refineries and things like that. Now, in that ruling, the majority determined, as the Legal Information Institute at Cornell Law states, quote, the legislative history is consistent with the view that the EPA should have broad discretion in implementing the policies of the 1977 amendments, end quote. In other words, In 1984, the judicial branch ruled that anytime there was sufficient so-called ambiguity in an establishing statute for an agency or in a new statute for that agency to enforce, an agency of the executive branch should have such broad discretion that the agency could act as a de facto legislative branch and create its own powers. Should a victim of this new expansion want to appeal the expansion, the appeal wouldn't be heard by the courts, but instead, you got it, would be heard by the regulatory agency that just expanded its own power. If you detect a lack of due process and the easy possibility of unjust punishment here, if you see violations of rights that are supposed to be protected by the 5th, 6th, 8th, and 14th Amendments, well, you're on target. But that is not where the majority went on Friday. No, instead, they ruled on the separation of powers and what such leniency for regulatory agencies in the executive branch does, which is to take away what the majority of the Supreme Court justices believe is a judicial branch purview. As Jacob Sullum writes, for reason, quote, critics have long complained that Chevron deference allowed bureaucrats to usurp a judicial function and systematically disadvantaged the little guy in disputes with an overweening administrative state. The Supreme Court endorsed that critique by a 6-3 vote today, repudiating the idea that agencies, rather than judges, should resolve ambiguities in the statutes under which they operate, end quote. Indeed, in his Loper-Bright majority decision, Chief Justice John Roberts cited the 1946 Administrative Procedure Act, itself a result of the toweringly unconstitutional profusion of FDR-era regulatory agencies that, of course, have expanded in number and offense ever since. As Cornell's Legal Information Institute notes, quote, and they're talking about the 1946 Administrative Procedure Act, the act established how federal administrative agencies make rules and how they adjudicate administrative litigation, end quote. Now, Roberts and the majority found fault with the Chevron standard theft of what they see as a judicial function, and now they're pushing back. As Sullum observes, quote, writing for the majority in Loper-Bright Enterprises v. Raimondo and Relentless v. Department of Commerce, Chief Justice John Roberts notes that the Administrative Procedure Act, APA, incorporates the traditional understanding of the judicial function under which courts must exercise independent judgment in determining the meaning of statutory provisions. He says the deference that Chevron requires of course reviewing agency action cannot be squared with the APA, end quote. And Sullum notes Roberts' additional comment on this problem. Quote, the Chevron doctrine defies the command of the APA that the reviewing court, not the agency whose action it reviews, is to decide all relevant questions of law and interpret statutory provisions, Roberts writes. It requires a court to ignore, not follow, the reading the court would have reached had it exercised its independent judgment as required by the APA. It demands that courts mechanically afford binding deference to agency interpretations, including those that have been inconsistent over time. Still worse, it forces courts to do so even when a pre-existing judicial precedent holds that the statute means something else, unless the prior court happened to also say that the statute is unambiguous. That regime is the antithesis of the time-honored approach the APA prescribes, end quote. Of course, that so-called time-honored approach really isn't the core of the problem, and Roberts didn't address the deepest issues here. Taking it from the immediate controversy on the matter of the fish counters, one reasonably could conclude that no agent of a constitutional U.S. government should be demanding access to a private abode or piece of private property without a public warrant issued by a judge upon the judge's determination of probable cause. Such a standard is explicitly established by the Fourth Amendment. And the federal demand that commercial fishermen admit government agents onto their boats fits very well in the Fourth Amendment standard. It also fits with the Fourth Amendment prohibition of those government agents collecting any information about what is happening on the boats. Without a warrant, any so-called fish counting on or off a boat itself is a clear breach of the Fourth Amendment.
9 fish. 10 fish.
So, ruling 6-3 in the case with Justice Elena Kagan, Sonia Sotomayor, and Ketanji Brown Jackson dissenting, the Supreme Court has claimed back the judicial power over questions of so-called ambiguity that for 40 years have been answered by the very government agencies that expanded their own power. And for now, the fishermen have won half a battle, but not the war. They won't have to pay for federal fish monitors, but they'll still have to house them in berths on their boats and welcome them to invade their private businesses, contrary, of course, to the Bill of Rights. So there remains a very large cost. It's the cost in loss of sovereignty and the continued dismissal of the U.S. Constitution by those who swear oaths to uphold it. That's the dark side of this victory. Thanks so much for watching, everybody. Please like and subscribe. Hope this exploration has been interesting, and I hope it provides you plenty of good information to pass on to others. Please feel free to share our videos, especially from Rumble. Love to see all the people visiting Rumble. Remember to hit the follow, and of course, you can find us on YouTube, where yes, they do still sometimes censor us, and do make sure that you're subscribed over there as well. Find us all the time at MRCTV.org, MRCTV.org. Check out what the whole team is doing. Open up that new tab on your browser and see what's happening over there. And while you're there, please consider contributing to the Media Research Center and check out the MRC-TV store. Great stuff there. You can find us inside Facebook. It's always jumping there. On Instagram, on TikTok, on X. And if you want to visit me on Gab, I'm at Gardner Goldsmith, or on X, I'm at Gard Goldsmith. Thanks so much for watching, everyone. For MRC TV, I'm Gardner Goldsmith.
I want to invite you as my guest on a very special, once-in-a-lifetime, 7-day post-election cruise in the Caribbean. It's going to be a blast.